If you're preparing for a sentencing hearing, do you think it would be important that your lawyer reviews and reads all of the character reference letters? What do you think? So if you determine how many letters you should obtain based on research or knowledge of the judge, you then send those letters to your lawyer. Do you think the lawyer should read the letters? Now, some lawyers may say they read the letter, but may not actually read. may not actually read the letter. They may just get added as an addendum to the sentencing memorandum without being read. I share this because it's 8:30 in the morning on Wednesday. I'm getting ready to go to Los Angeles for the day. And I received a call from a defendant, and I won't get into the specifics of the case, but it's someone we'll be working with, who called to tell me that his judge was furious at his sentencing hearing last week. Absolutely furious at the boilerplate nature of his character reference letters. They all looked the same, with sort of the same opening and closing. Very little specifics to the defendant, but more so, it was the boilerplate templated nature of the letters. And I said, well, tell me how that could happen. Help me understand how the letters weren't reviewed and why you didn't read them. I mean, didn't you reach out to people and encourage them to write a letter or express your gratitude for sharing details about your character? How could this possibly happen? And what he said was his lawyer told him that he didn't want him to read the letters for whatever reason. And the letter should go directly to the lawyer. And of course, he trusted his lawyer. So these letters from people who wrote these character reference letters probably couldn't have taken him more than 5 or 10 minutes to write the letter. These letters went directly from the person who wrote the letter to the lawyer. And apparently the paralegal in the office kind of coordinated the project. So for example, Joe, thank you for agreeing to write a letter for Jim. Here's some information, even a template on how you should write this letter. Here's some advice to help you. Please address it to the judge. So all the formatting was the same. A lot of the opening and closing was the same, and some boilerplate stuff in between. From there, the letters were returned to the law firm, added to the memorandum, submitted to the court, and the judge was upset and essentially called this defendant lazy. Think about that for a moment. All the hard work this defendant could have done, or I believed that he worked while he was preparing for sentencing, owes a lot of money, was unable to pay any money back, worked leading up to sentencing, did well on on pretrial services, avoided problems, no drama, didn't need to travel. Everything was, he did fine. He did fine, didn't turn in a personal narrative, fine. The lawyer told him not necessary. Okay, I think that's terrible, whatever. That doesn't hurt as much as a judge thinking that you approach this process from a perspective of doing absolutely as little as possible. Imagine how hard a federal judge worked to become a federal judge, the time invested to become a federal judge. Do you think that it would make sense to invest as much time as possible to convey through authenticity why you're worthy of leniency, including the character reference letters? So I don't know if this person would have gotten a shorter sentence if he had turned in original, compelling letters. I think it would have helped him. But you can see how before a judge renders the sentence, it probably doesn't help if he's been filleting you in this courtroom, essentially calling you lazy by turning in boilerplate information. And to the defendant, I really empathize with him, right? He was told he couldn't read the letters. It's kind of the same. It's like a lot of defendants are told, the lawyer will say, I'm not allowed to give you your probation report. Well, it's my probation report. Email it to me, send it to me. I'm not allowed to do that. So a lot of defendants will say, okay, you're my lawyer. I trust you. That makes sense. So following the sentencing hearing, the lawyer didn't say much other than to say it wouldn't have mattered anyway. The judge's mind was already made up when we came into it. That's the rationalization or the way the lawyer could defend his position. And of course, you'll never know. He's only going to be sentenced once. So if you're going to obtain character reference letters, make sure that they're not boilerplate. Make sure that they speak specifically to your character. Make sure that you are reaching out to people and nurturing relationships and expressing gratitude that they took the time to write the letter. And make sure you review and actually read the letter. And make sure as well that your lawyer has reviewed and read the letter. Why? A federal judge is going to read it before rendering sentence, and you do not want to be accused of being lazy or turning in boilerplate language that essentially all these letters had like the same language again and again and again. It's clear they had been given a templated document and no time was invested. Learn from these mistakes and you'll be better off.